Hi there, this is Jonathan Ginsberg, and today I'd like to talk to you about the strategy I use in Social Security disability cases when my client has been impaired by a stroke. And I've seen more and more of these cases. Usually they arise from long-time hypertension, high blood pressure, although it can come from other causes. Usually my clients are going to be in their 50s, even early 60s. But obviously a stroke could be a fairly debilitating and very disconcerting type of thing to have happen, and folks who have strokes will frequently file for Social Security disability, and those are usually pretty good cases. And I want you to understand how I approach these cases. There are basically three ways you can win a stroke case. All three ways that you can win Social Security cases really can apply to stroke cases. Method one is to meet a listing. And Social Security's listings are where Social Security has published in something called the Code of Federal Regulations specific medical descriptions of various conditions that on their face are so disabling that one would be considered disabled without having to go any further. So a stroke is a listing level condition. And I'll talk about that more in a second. The second way to win a stroke case is to argue functional capacity. What I mean by that is that when you have a stroke, your capacity to perform even simple entry-level unskilled work will be impaired. And if you have a vastly diminished functional capacity for work, you can be found disabled on that ground. And the reason why it's important to also consider functional capacity in addition to listing level impairments is even if you meet a listing, some judges feel that at the hearing level, they should really only be deciding cases on functional capacity. They feel that a listing level case should have been caught earlier, and so judges, not all of them, but some of them are reluctant to find somebody disabled on a listing at the hearing level, so you need to have kind of a second approach in your back pocket if that's the situation. Typically what I'll do is I'll present both. In other words, I'll present a listing level argument, and I'll say in the alternative, we would like to argue functional capacity. The third way to win is the grid rule approach, and the grid rules, as I've discussed elsewhere, and I'll put a link to where more discussion about that is here. A grid rule is where a person who has a limited education, limited work experience, can be found disabled even if they retain some functional capacity to work. So in other words, a person who is, let's say, 55 years old with a high school education and no transferable skills can be found disabled even if that person can do sit-down work, or even if that person can do light work, because Social Security recognizes that a person over age 55, and there's also grid rules that apply for people over age 50, if you have a limited work experience, limited education, you're going to have a difficult time getting back into the workforce, and you can be found disabled even if you can still do some things. So it's kind of an offshoot of the functional capacity argument, but it only applies to people with physical impairments. So let's talk more about the listing level impairment. The listing for a stroke is going to be found at 11.04. This is what they call a central nervous system accident. And typically at the listing level, you've got to show that your stroke has either impaired your speech, so you can no longer communicate effectively, and that can also be memory, or you can show that it has affected your capacity to use your arms and your legs. And really, the focus is probably more on walking. So if your stroke leaves you without the ability to communicate effectively, or if it leaves you without the ability to walk or even use your arms effectively, you can be disabled on the listing. And typically the way you pursue a listing level case is you have your doctor, treating doctor, neurologist, neurosurgeon, fill out a form that basically tracks the language of the listing. When I have a listing level case, I will take the listing itself, I will create a checklist form, throw a few other things in there, get it to the doctor, have the doctor fill out the checklist, make some notes, and submit that, and that's usually enough to win the case. And again, listing level impairments don't require a lot more investigation into functional capacity, but you do want to show that the listing level impairment has caused some impairment to the person's capacity to do activities that would be equivalent to work-like activity. But that's basically the listing level impairment. The second way to win, which is the functional capacity argument, is where you argue that your capacity to perform simple entry-level work has been so reduced that you could not do, again, even what I would call a warm body job, just a job where you have to show up, something where you're sitting at a table packing ink pens in a box is a good example of a warm body kind of job. There's no interaction with coworkers or supervisors, there's no decision making, you're not on a high-paced environment, you just have to be there and be there reliably. And when I'm arguing functional capacity, I'm going to argue that my client's attention and concentration has been impaired. They would have problems with appropriate pace of work. They would need to take too many unscheduled breaks. They would miss too much time from work. They would not be able to get through the day without emotionally disturbing symptoms. Again, frequently stroke victims are frustrated. They can break down in tears. I had a case recently where my client became so frustrated at the hearing he started crying because he couldn't remember just really basic type of things. So I think functional capacity, what I do is I'll take a functional capacity form, kind of the generic form used by Social Security. There's actually a generic form for mental functional capacity problems and physical ones. I'll kind of combine the two, and that way I've got a good functional capacity form that can be used for a stroke victim. And again, it contemplates both the physical as well as the emotional and the mental limitations that arise from a stroke. The conclusion would be that the patient would not be able to perform reliably at any kind of work because of the combination of symptoms. And the grid rules, as I talked about previously, really focus on the physical limitations, and it really applies for people over age 50 with limited education, limited work experience, and you can argue that as a result of the physical problems that arose from the stroke, such a person would not be able to perform at a certain level of work, would not be reliable. But again, even if they could do sedentary work or light work, depending on the particular grid rule itself, such a person would not be able to do any more than that and would therefore qualify under the grid rules. And that's really something your attorney can help you with. When I'm representing somebody, I always look at the grid rules, and we'll go into that kind of inquiry. But just be aware there's something out there called the grid rules, that it does apply in stroke cases because of the physical manifestations of the stroke. The other thing I'd like to let you know about stroke cases is oftentimes there is a two-part argument. And the best way to describe this is that you typically have a stroke event and then the post-stroke implications, and you have the pre-stroke implications. And a lot of times somebody who has a stroke, looking back, you will see that they were having bad headaches, they were having dizzy spells, they were having periods where they'd get up and be lightheaded, or they'd faint, or any number of things. And sometimes those pre-stroke indications, they may have TIAs, little mini strokes. Those pre-stroke indications, when you look at them, could be disabling on their own. I recently had a case where a client had a stroke a couple months before the hearing, and clearly as of the hearing date was disabled, but the question was, for the year and a half prior to the hearing, was he disabled? And I was able to show that he was, because I had testimony, and actually from a daughter, that he was having terrible headaches, and he was having dizzy spells, and he was not able to concentrate. He would forget what he was talking about. And all these things leading up to it, his blood pressure was always at 180, 190, 200. I mean, it was very, very high. And we were able to show that even though he didn't necessarily realize that he was having sort of these pre-stroke symptoms, in retrospect he was, and that his capacity to perform any kind of gainful work was pretty reduced at that point. The judge, who is actually a judge that doesn't really approve a lot of cases, accepted it. And what she ended up doing was, she said, well, if you'll amend your onset date to the date of his 55th birthday, which was about a year after we originally alleged onset, she would go ahead and approve that case, and so she did. So she kind of combined the grid rules, functional capacity, and even the listing. I think that it was kind of a unique approach to it, but she felt comfortable using the grid rules because she realized that after the stroke, clearly he was disabled, and she was willing to recognize that prior to that time, He had some pretty significant impairments as well. So that's how I deal with stroke cases. If you or a loved one has had a stroke and believes that you were disabled either before the stroke or certainly afterwards, please feel free to give me a call. My number is 770-393-4985, and I'd be happy to explain to you how any of these theories or arguments for disability might apply to your case and how you might be able to collect disability benefits. So again, this is Jonathan Ginsberg. I hope this has been helpful, and we'll talk to you soon.